I'm going to look at the employment aspects of auto-enrolment pensions, largely around the issue of assessing your workforce. So the first thing really you need to do is assess your workforce as to who needs to be auto-enrolled and who doesn't, but unfortunately it's not quite that simple, of course. I'll also briefly look at the consequences of not following the auto-enrolment pensions legislation. And then I'll hand over to Tim to cover the more specific areas around auto-enrolment itself in terms of staging dates, in terms of the key areas of compliance you just need to be aware of, what to do if you have an existing scheme in place and how that fits in with all this legislation, the contributions issue, how much you need to contribute and how much your employees need to contribute, and then just a sum up of the whole process. And Tim's very much taking the view that this is something we need to do, and I agree with him, so let's make it work for everybody. In assessing your workforce, the first thing you look at is how many eligible job holders you have within your workforce. They're the important ones, they're the ones that have to be auto-enrolled. So we'll look at the definition of eligible job holders in assessing your workforce. There's also, to bear in mind, non-eligible job holders, which are those who don't fit into the first category, but have some rights under the law of auto-enrolment. They have the right to opt in if they want to, and if they opt in, you must then make contributions. So to some extent, they are the people that we currently employ, if you like, in terms of how we currently offer pension. So a lot of employers may have a pension scheme which people can opt into or not. So to some extent they are sort of sitting in that category, and they have different rights to eligible job holders. And then we have another category of entitled workers, who are those that have the right to opt in, but if they do opt in, you don't have to pay any contributions to their auto-enrolment pension. I will focus on eligible job holders because within your assessment they are the important ones. They are the ones who have to be auto-enrolled finished, unless they opt out. So eligible job holders, looking firstly at job holders because that's also a piece of terminology that we use for non-eligible job holders. And a job holder is a worker with a contract. Yeah, he's glazed over already. A worker with a contract. So this is beyond employees, and this is the key point I need you to take away from today. It's not just your straightforward employees who you may have to auto-enroll, who may be eligible job holders. Ordinarily working in the UK, at least 16 and under 75, and paid qualifying earnings. So the qualifying earnings band for 16-17 is earnings between 5824 and 43. So anyone earning over 5824 is a job holder. We then drill down a little bit more to the eligible job holder. Remember that person who must be auto-enrolled in your workforce. That's a job holder, so they fulfill all of the previous requirements, including the worker category. Age 22 to state pension age, which unfortunately we can't even state simply anymore either, so that's something you need to be constantly aware of, and whose earnings exceed the earnings trigger, which currently is £10,000. And that's been the case for 2 years now, but that may change as well. But note that once enrolled, and I think Tim will touch on this a bit more, once enrolled, the contributions payable are in relation to the entire earnings trigger, the entire qualified earnings band. So contributions must be paid on all earnings over 5824, not just earnings over 10,000. But Tim will touch on that a little bit more later.
A worker with a contract, that's a verbal contract as well? That's
absolutely right. So yes, so we then looking at identifying a worker on the next slide. Sorry, this is anybody with a contract of employment or any other contract. So it's not just an employee, and that contract can be in writing or verbal, or in fact implied just by virtue of you having worked with this person on a fairly set basis for a reasonable period of time.
What about subcontractor?
Yes, we're going to look at different categories of potential worker in a minute, but a subcontractor, depending on how that relationship works, may well be a worker. This is somebody, you're also looking at somebody who performs work personally for a party who is not a customer, so this is not a business-to-business relationship. So your subcontractor may be a very business-to-business relationship, in which case, no, they're unlikely to be in the worker category. Those working notice don't have to be auto-enrolled, just worth noticing. But the big thing is that you're talking about more than just employees here. You are talking about a wider scope of individual. And particularly in small businesses, a lot of small businesses do work with different types of individual. They don't necessarily have only straight employees on their books. So this is just how it's broken down. You've got your workers, which include all your 3 categories of individual for auto-enrolment. And this is all new terminology, which is not helpful in terms of we don't really use the word job holder any other time when we... Okay, so worker, within that we've got job holders, so that's looking at people within the 16 to 75 age band and earning over the earnings trigger, the 5824, and then within that we've got our eligible job holders, who are our people who have to be auto-enrolled. So looking at that worker thing, which is a concept which is largely developed over time, largely coming out of a lot of European legislation, to extend rights beyond just your straight day-to-day typical, if there is such a thing, employee. So workers include typical employees, who you can probably identify relatively quickly. They've got a contract with you, you treat them as employees. But they also include potentially, and we'll look at all these categories one by one, agency workers. We look at directors. There's a specific, luckily, very recently, they've introduced a specific carve-out for directors. Consultants and the self-employed, maybe workers, depending on how the relationship works. Casuals, volunteers. Does anyone have volunteers so I can know whether to... No, okay. Secondees, so you might have somebody seconded to you, or you might be seconding somebody elsewhere. And then fixed term workers, a bit of a misnomer, they may be employees, they may not, again, depending on how the relationship works. Part-time, really that's the part-time issue there is going to be irrelevant to considering their status. Somebody can be very much part-time employee, as I think we're all quite comfortable with these days. Agency staff, agency workers, have actually been specifically included by the auto-enrolment legislation, which in all honesty was quite helpful, because agency workers have become more and more confusing, so frankly they decided not to leave room for confusion and to cover it. So agency workers are eligible job holders. But what we then need to look at, and what's important for you, is who then is responsible for auto-enrolling them and paying the contributions, the employer's contributions, and whoever in fact pays them is largely how we determine it, will be the business that is responsible for the auto-enrolment, which would usually be the agency. There will be, however, what you need to be aware of, and this has been seen with other legislation around agency workers, is that there will be a cost pass-on to some extent, in terms of there will be an increased cost to the agencies, so there will be an element of pass-on over time in terms of that cost. Do many of you employ agency workers? No, sometimes, just to... Okay, and please do feel free to ask questions throughout. We will have question times at the end, but do...
Okay, I do employ agency staff, but only for very, very short periods of time. I've never paid one
direct.
5,280. I've never been charged
okay, well that's...
for an agency member of staff over the course of a year. Would that mean that I'm not on the hook for it, or is it just that my price is going to go up because of Reed or a Deco or whoever I'm getting?
Potentially, yeah. Because it's going to be not how much they farm them out to you, it's going to be how much they place them finished for the agency if they're doing the paying. If effectively the contract is between the agency worker and the agency, and the contract and your contract is with the agency, it's the agency's problem, but it may still become a cost issue at some stage. But that's for negotiation with the agencies. Directors, this was a bit of a grey area, but has been clarified as of April 2016. Directors don't have to be auto-enrolled. So statutory Companies House registered directors don't have to be auto-enrolled. There is a discretion to auto-enroll them, and this is for both director-only businesses and businesses which employ employees other than directors or have workers other than directors. So that's okay. And are there any LLPs, partnerships, LLPs amongst us? Okay, so there's a similar exemption for LLP members. Non-exec directors potentially could take advantage of the same exception, but not always. But in any event, non-exec directors will not usually be workers in the traditional concept of workers, because they don't have a contract per se. They have a letter of appointment, and they might get expenses for attending board meetings or the like, but they're unlikely to be workers. So we come down to the assessment of consultants, which really focuses the mind in terms of looking at whether, looking terrified, whether they are workers or self-employed genuinely. Because if they are workers, they are eligible job holders potentially if they tick the boxes on age and earnings. So we look at various factors in determining whether consultants are workers or not. The three biggies for law, and we'll look at the more practical points afterwards, are do they provide personal service? Do you expect, so you contract with a consultant or even their personal service company, but do you expect the same individual to do the work? Or is there a provision for substitution that is actually practically usable, or do you expect it always to be that individual providing the personal service? If it's personal service, you've got to tick potentially worker. We then look at, is there an expectation by that individual now, we're really drilling down to that individual, for you to provide them with work, and do you expect them to do the work? So if over time the relationships evolved so that they're actually kind of working for, they might do work for one or two others, but pretty much they work for you 3 days a week or whatever, and they would be a bit shocked if you said, actually, I've got nothing for you for the next 3 weeks, and they always say yes. You've potentially got mutuality of obligation, so another tick for them to be a worker. Controls.
When would it not be in their interest to say yes?
Sorry, to getting work?
Right, no. From a mutual obligation point of view, if you asked, basically what we're saying is that I would say no, they would say yes. I'm trying to think of a situation where they would then turn around and go, oh, no, I don't need the work. Yeah, you shouldn't pay me a pension as well.
Well, it would. What we're looking at here is how the relationship has worked. Nothing necessarily to do with the pension per se.
I know, but the way you said that you phrased that was that basically what we're saying is that a consultant who has been getting regular work from us. Sorry to everybody who hasn't got consultants. I've got loads.
No, you're not alone.
Mutual obligation side of things. If I've got someone who I pay every month, because they do different work, but they do different work for me every month. Ultimately, they're going to say at the end of it
that
yes,
they
I
are.
expect it. I can't see why they would ever answer no. So that's not really a mutual obligation. It's just a case of if they can show me an invoice from every month, then it doesn't matter what they're what.
Yeah, I'm going to look at the practicalities. As I say, these are the three legal tests, which are little bit dull. We'll look at the sort of how your relationship actually works, if you like. But these are certainly worth bearing in mind. The other is control subordination. So if you've got a genuine subcontractor, for example, and you say, I mean, that's the best comparison, and you say, okay, ABC Limited, I need you to do this project. I don't care how you do it, when you do it, what. I need it finished by this date, but you get on and sort out what people you need, and I'm just giving you a lump sum of this. That's going to be a subcontract. But as soon as you're saying, okay, Joe Bloggs, you know, I want you to do this like this by speaking to these 3 people tomorrow, then you're starting to get into control factor as well, which is more likely to be a worker.
What happens if the consultancy firm is just one person? So it's like you're forced
Well,
to use
you
that
start,
document.
yeah, you're starting to look more, you're getting away from, you've probably got a personal service issue, and you probably, the relationship might have evolved
Right.
as a worker relationship. It's more likely to have evolved as a worker relationship just by virtue of the fact.
A lot of consultancies out there are just single people.
Exactly, and they effectively use
Yeah.
personal service companies, but ultimately they are an individual, and that's what this is kind of all about. This is exactly.
3 days a month.
Yeah.
So she's been with us 6 years.
Right.
She works for other people, but she invoices us, and we pay her as a subcontractor.
Yeah, it's
You can talk
probably-
about that, can't you, Kate, but
yeah.
It also depends how much work these consultants do for you, as opposed to how much work they might do. If they're working exclusively, let's say for 2 people, there's a potential that both employers, if I can use that word,
Have to
require
pay,
auto-enrol
yeah.
that person for the earnings that they take
So-
from each.
So it won't necessarily be only the one business. Exactly, it's not a choice. It might be the both.
It's just going to make it difficult for people, to contractors that are working on their own, to actually get work in the future, because they're going to be looking at it saying, I'm going to have to give you a pension.
Well, we would hope if the auto-enrolment scheme is set up that it wouldn't be too much of a bind, but it will be a cost implication. But that may be, that may be something that's just factored in the overall deal between, in terms of payment.
I think the thing is that this is all new.
Yeah, we'll have to see.
It's like any other benefit that an employer cares to give to an employee. Once it's started, it's running.
Yeah,
It's like anything
yeah,
else.
it's there
Getting
once.
used to it and getting your head around what you've got to do.
I mean, the thing is worth noting, I don't know if this is good news or bad news, but effectively workers are also entitled to holiday pay, for example, not just employees. So it's the same concept that we've actually had for working time regulations, workers, and they're entitled to holiday pay. Okay, but that's a whole nother day. Okay, so looking more at the practical factors, frankly, in terms of your relationship. So if you've got somebody who pretty much you pay a fairly regular wage, even if I'm honest, if they invoice, but if they're invoicing for exactly £2,500 every month, we're starting to say, okay. If you offer them any benefits, or in the same way that you offer your employees, which are clear employees, then obviously we've got a potential tick against the worker category, but that's probably unlikely.
What did you say, Kate, last time? Christmas party?
Oh yes, we get on to integration, yeah. Who provides their tools and equipment? So if they are expected to just provide their own stuff, probably a tick, that's indicating not a worker, but we do have to balance up this shopping list of factors. So that doesn't mean they're not a worker, but it's something that you then balance against the other factors. Whereas if you were providing all their tools, a desk, a PC, whatever, you are providing tools and equipment. Integration, as Tim says, we look at integration. It's silly things like, do you invite them to the Christmas party? Do they go on away days? Have they got a company email address? Are they on your telephone list? Have they got a company mobile phone? Integration issues. Tax, who sorts out their tax? Again, only a factor, because quite often that's not determinative. How the revenue assesses individuals for tax and how you're expected to assess for auto-enrolment and indeed for holidays can be different, but that is a factor to look at. And financial risk, and that's a nice one, because frankly, if you've got a subcontractor who's potentially taking a financial risk, you give them a project and this much money and they need to get it done. If they make a profit, great. If they make a loss, that's their problem. Unlikely to be a worker if you're in that sort of situation. I don't deny it's not straightforward. As I say, this worker concept has been something that's been around for a while, but I think auto-enrolment is to some extent going to bring it into sharper focus, because these are individuals who basically the government has decided need a pension, and this is how it's going to be provided for, and that's fine. Casuals, you're going to have similar discussions, similar arguments around casuals. We've got our different types of 0 hours who might work for you from time to time for a long time, or might just be seasonal for particular times of year when you encounter higher workloads. A casual who's just coming in is likely to be a worker even if it's for the short period of the summer, 2 months. However, you can use the postponement mechanism whereby you can postpone auto-enrolment for 3 months provided you tell them that's what you're doing, and therefore you won't have this putting these short-term workers on your auto-enrolment scheme necessarily. But there is a lot of complication around casuals because potentially casuals can have umbrella contracts. So if you expect them to work for you, so you have this bit of type of work that they do only crops up in February, June and September, and they work for you February, June and September every year, potentially you've got an umbrella contract, which is actually going to tide over the gaps. But it's probably unlikely for most genuine casuals who are very much come and go that you would need to auto-enroll. But the 0 hours thing is often not really that. So you need to be aware of the more regular 0 hours workers. I'll skip volunteers. Secondees, anyone? There was actually somebody previously in the previous session. I mean, effectively, it's the seconding employer who will be responsible for the auto-enrolment duties, so not the host. So if somebody is seconded to you, their original employer should be sorting this out, but if you are doing the seconding, that remains your responsibility. As I say, fixed term, again, we look at the same things that I've mentioned for workers. They may be fixed term, but they're likely to be employees, frankly, depending on how it works, and at least workers. Okay, so just be aware of that's just to flag up, be aware of the fixed term people on your books. So, in assessing your workforce, easily said, isn't it? You need to identify who's the worker. Do they work in the UK? We look at pay reference periods, which I won't go into any huge detail on, but you obviously need to say, okay, how much are they paid by me? And then you compare that pay with the earnings trigger of 10,000, which will put them into the, provided they satisfy the other points, eligible job holder category. And then you look at the qualifying earnings threshold, which is where you need to pay your contributions. So that's kind of your groundwork for auto-enrolment in terms of your workforce. Any questions at this point?
Just got one, and I think it goes back to one of your very first slides.
Sure.
Did you say something about age from 22?
Yes,
Just
that's
that
right.
we've recently got an apprentice who's now out of apprenticeship and she's now a full-time employee, so she's 19. So does that mean she doesn't have to auto-enroll?
Yes, she may be a non-eligible job holder, so she may be able to opt in if she wants to,
Right, okay.
but not auto-enroll. No.
Okay, so she's got the option to opt in or
That's
opt out.
right, probably, depending on a couple of other factors, but it sounds almost certainly, yes,
Okay.
yes. And you would then need to tell her, so provide her with information that she can opt in if she wants to, and then you'll have to pay contributions, but it is an opt-in rather than an opt-out, which is what the situation is for eligible job holders.
And just one other thing,
Sure.
For people that do actually employ consultants,
Sure.
aren't consultants actually employees of their own companies? So are they not sorting out their own auto-enrolment, and why should it be
Not,
the employer?
I know,
Who actually-
not necessarily.
Right, okay.
The personal service company, IR35, all of this, it's the same confusion, and I suppose, and ultimately these people, if you look at it in reality, are not really consultants, and that's what we're trying to catch, if you like. I don't like to use the word catch, that sounds, but yeah, that's what's trying to be also wrapped up in auto-enrolment. But yeah.
I mean, it's funny, we've run this seminar in a number of centres, and I think one of the big questions coming up is around consultants, casual workers, and how casual is casual to mean that you're not responsible for them. We had quite a large building firm in one of our other centres that was using a lot of casual drivers to do various bits and pieces, but they were casually employing them regularly, and therefore they become a worker. And you know, we had this big dispute over, but they're casuals, they're not actually even on our books, and we don't have a contract with them, so, but you are paying them probably once every 2 months at regular intervals for this kind of stuff. And I think that is probably the biggest question that's come up in terms of going back
Just
and really
assessing
thinking about
the workforce.
how much time, what's the regularity of your interaction with somebody else who might not be from your company, but how many times do you pay them a year? What do they do for you? You know, are you 2% of their total business, or are you 98% of their total business? So there's a lot of things that.
It would be easy if there was
absolutely.
guidelines. You could say, right, okay,
Yeah,
someone works for us 24 hours a month.
I know.
Pages of guidelines. If you
Yeah, I would have,
Yeah.
I mean, it's, you know, it has.
yeah. So, but it, obviously the onus is upon us to obviously.
Assess, yeah.
Yeah.
Yep.
That's right. Yeah.
So technically, if I have a number of pieces of bespoke IT work that I need, and I go to a series of consultants and I ask each of them to quote, then the one who does the work for me, he's taking the financial risk.
Yeah, potentially. Yeah. I mean,
So all I need to
if
do
it's
is
if
put
it's
all
a,
of my consultants on effectively on an ITT, rather because that's effectively what I do.
You
I
make
basically
sure-
say to them, right,
yeah.
okay, I need this, I need it to do that, and then
Okay.
it's a case of
okay, you
go
just
get
get it
that
done.
please, because my support team have got other
Yeah.
things to do.
That's fine. It's becoming more of a business-to-business
Yeah.
relationship then,
Right.
and they
okay,
are
that
taking
needs to be-
financial
so
risk,
that
but that
actually
needs to be
be divided into
clarified.
full
Yeah.
Okay, that's fine. I'm a lot less stressed.
Okay, just looking then at what changes you'd need to make, for example, to your contracts of employment. You might have, if you with your genuine straight employees, or your other contracts indeed. Contracts of employment though with employees have to state certain things, and one of those things is the pension arrangements. If you've had no pension arrangements, or you've had access to a stakeholder pension, for example, that might currently be stated in there. What we are saying is just provide a fairly generic, we will comply with our obligations under the Pensions Act, and that's pretty much what we're saying at the moment. If you have had pension arrangements in place for your employees, and those have been fairly detailed in the contracts, then you would need to make changes to the contract through some sort of consultation. But if you're simply introducing auto-enrolment, if you like, then you just need to state, and there doesn't have to be any consultation or any consent. This is a requirement of law, finished. Okay, there are certain work safeguards in place, so just be aware of, you can't say to somebody, I'll only hire you if you opt out of auto-enrolment, for example. You can't say, I'm going to sack you unless you opt out of auto-enrolment. And there are more complex detriments. You can't sort of say, okay, I'm introducing auto-enrolment, but everybody's taking a 5% pay cut. Can't do that either, I'm afraid. And if there is protection for employees who report to you to the pensions regulator if you don't comply, etc., under whistleblowing legislation, which we're kind of all a bit comfortable with, I think, now. And finally, if you don't, what happens to you? The pensions regulator will issue a compliance notice first and foremost if it comes to their attention that you haven't auto-enrolled any of your eligible job holders at all, or indeed you haven't provided your non-eligible job holders with information on their rights to enrol. They can issue a compliance notice saying you must do X by Y, and if you don't do that, then there can be a series of fines, depending on how long you still resist or whatever else. Just to bear in mind, people have said to me over time, or can we just get them all to sign some sort of compromise settlement agreement whereby they say that they're not, they don't want to auto-enroll and they're signing away their rights to do anything about that. No, you can't. That's a different issue. That's generally settling employment rights with the individual, and this is a pensions regulator issue, so the pensions regulator will not be prevented from taking their actions by any sort of settlement agreement. Okay. Any questions at this stage? Tim's going to move on to talk about the nuts and bolts of the system. I mean, one thing I think is probably worth emphasising is that your eligible job holders must be auto-enrolled, so they are automatically enrolled. They can opt out, but they must do that themselves once auto-enrolled effectively. But you then would have to auto-enroll them again 3 years later. So that's So that's a continuing requirement, and you should always be assessing your workforce, because we've got things like changing ages. We're going to have changing earnings triggers, qualifying bands, state pension age, all of that. So it is kind of a bit of an ongoing process. And obviously relationships with some of your workers might change, which some of your consultants might change over time as well. Okay.
See how easy it is?
No worries.
Thanks, Kate.
Okay, thank you.